and we're here today to talk about the new Central American Minors Program, also known as the CAM program. So let's get started. So I'm sorry, I seem to have skipped. There's my agenda. So let's start by talking about logistics and asking questions. If you have a question during the presentation, please type it into the question box, and I will address it either at the time or if I see that it's a question that will be addressed in a later slide, then I'll just wait and address it in the course of the program. And if you feel that I still haven't answered your question, please go ahead and type it again or just send me a reminder if you feel that I haven't answered a question by the time we are finished. So as far as our agenda goes, we're going to start by doing an overview of this new program. We're going to talk about the key issues of the CAM program. We're going to go over the eligibility requirements. We'll talk about the parole option, which is a new feature. We're going to talk about the requirements of what needs to be submitted. We'll also talk about how the new CAM AOR is different from the AOR for the P3 program. We'll go over the way that you submit the CAM AOR, and hopefully at the end we'll have time to review the actual form, the new CAM AOR form. So let's talk about an overview of the program. So this is an in-country processing of a new P2 group, and that group is defined as unmarried children under the age of 21 who are nationals of and living in El Salvador, Guatemala, or Honduras, and have a parent legally present in the United States. The State Department has stated that their goal in establishing this program is to provide a safe, legal, and orderly alternative to the dangerous journey that some children are currently undertaking to the United States. They have indicated that they know that this is not going to solve the border crisis, but that it is a good first step in addressing the problem. So what's interesting about this is that it's, like I said, a P2 in-country processing program, similar to like the Cuban program that you are all aware of. However, it's processed like the P3 program, using AORs, affidavits of relationship. So it's like a strange hybrid in a way. Now, only resettlement agencies, only affiliates like you can file these, just like with the P3 program. So that means the immigration attorneys, the coyotes, or the notarios that may be in your area, they may be all thinking that they can get in on this, but only agencies such as yours, only resettlement agencies are permitted to file these through their national agency. So what's also important is that in your outreach, you need to educate the public that this is a free program. There is a cost for the DNA testing, which we'll get to, but there's no cost to apply generally. And there is a fear that the notarios, which exist in many communities with a high Hispanic population, may try to take advantage and say that they're able to file these and charge a fee. So part of what you need to do is educate the public that there is no fee and that only resettlement agencies can file them. So as I said, it is similar. It's like a hybrid of the P3 and the P2 program, but there are significant differences between this program and the existing P3 program. First of all, the beneficiaries must be actually in their country of nationality for this program, which those of you who work on the P3 program know that is the opposite of the P3 program, where they must be living outside of their country of nationality, and they must be in a country of asylum to qualify for the P3. So that's a significant difference. And also in this program, there's the option of parole for those who don't qualify as refugees. That has never been offered before in any type of program through the State Department. I'll get into the parole option a little bit more later. But it's important to note that the people who get parole as opposed to refugee status won't be eligible for any R&P benefits or an IOM loan. And finally, this is a relatively small number of beneficiaries, at least starting out in 2015. The beneficiaries will come under the ceiling for Central and Latin America under the presidential determination, which is only 4,000 for 2015, and that includes all the Cubans and Colombians that have been coming as well. So this is not looking to be a huge number, at least right off the bat. So let's go over some of the key issues in this new program. Now, just as in the existing P3 program, using this AOR is to gain access to the U.S. Refugee Admissions Program. By filing this AOR, it is not a guarantee that the beneficiaries will be accepted. So it's all about access, not guarantees. Just as in the P3 program, the beneficiaries must prove that they have a persecution claim and they qualify for refugee status. Now, what's interesting about this program as opposed to the existing P3 program is, in the P3 program, everyone's already in a country of asylum. They've fled their country of nationality, and for the most part, they've already registered as refugees because, as you know, the requirement now of providing a proof of registration, they have to already be registered as refugees in their country of asylum. So they've already taken that step of proving that they're refugees and that they have a persecution claim. In this program, they're in their home country still. And so there is no, already having taken that step of proving refugee status. So these children are going to have to prove that they qualify as refugees under those 5 grounds. I'm not going to get into the definition of a refugee right now, but you can all look that up. And so this can be difficult in Central America. Many of these children are fleeing gang violence, for example. And gang violence in and of itself is not a ground for a refugee claim. There has to be some tie to the child is part of a certain social group that's being targeted, or maybe a religious basis. There has to be some other tie that ties to the qualifications for refugee status. So this is an important point that I think is being lost on some people, that it's not necessarily going to be easy to prove that these people qualify, these children qualify as refugees. As I mentioned briefly before, like in the existing P3 program, there will be a DNA requirement. So the beneficiaries, at least the ones who are claiming a child-parent status, again, we'll get into the details, but they must pass the DNA test. They also have to go through all the same security clearances and the medical clearances that are as part of the U.S. Refugee Admissions Program all around the world. So this does require an investment of your time, but I want to emphasize that this is not a choice. All the agencies are required to participate in this program. If you have a refugee admissions program, a refugee resettlement program at your agency, you're required to also participate in this program. So depending on your location, you may have a significant number of people walking in and wanting to apply for this. So you need to start thinking about if you need to access more Spanish interpreters, and who's going to be in charge of this, how are you going to manage this program at your agency. A suggestion that actually Dr. Tefera made to me in talking about this is that he really encourages you all to look for partners to partner with other organizations in your area, the Latino and Hispanic organizations, to see if they can help with interpretation, perhaps the initial screening process to make sure that the applicants are eligible. I think they could really provide a lot of assistance. And they're going to want to be involved because this affects their constituency, the people that they serve. And so you really need to think about also leveraging your use of volunteers in order to increase your capacity, because there is no increased money with this program. You have to do it with the money you already have. So think about using volunteers. But no matter who you partner with or volunteers, your staff, your agency must retain the ultimate authority for filing these AORs with ECDC. You can't pass along that responsibility to another organization. But like I said, they can still help with the screening and whatnot. in the early stages. Another key issue is that it's important to counsel the anchor, also known as the qualifying parent, which we'll get into, at the time of application on 3 important issues. So your staff need to counsel on these 3 issues. 1, there may be substantial protection needs of these children in the country of nationality. And as you all know, the refugee process is not quick. This may take a year, 2 years to go through the processing until the child can come to the United States. So in the meantime, they may have substantial protection needs. And so the parent needs to realize that it's a lengthy process, and that as of right now, the U.S. government and UNHCR are not providing any protection, so to speak. There's no sort of safe house people can go to or anything like that while they're awaiting processing. Perhaps down the line something like that will come up, but as of right now, there is no protection. So if it gets out that a child has applied for this program, perhaps that would make them a target in their community. These kind of things need to be thought about. Now, I will let you know that on the Advocacy Committee call today with RCUSA, we talked about this issue, and we're going to be putting together some written materials to distribute to all of you so that you, your case managers can have some of the concerns, in a written format, perhaps that you can hand out or that they can refer to, because of course not all of you are going to be experts on the protection concerns in these 3 countries in Central America. So we're working on putting that together, and I'll get it out to you as soon as I have it. You also need to counsel the parents on the potential outcomes of DNA testing, which is something we talk about in the P3 program as well. DNA testing may reveal that relationships that they thought that they had are not actual biological relationships, and so they need to be prepared for that. And finally, they need you're going to need to counsel the qualifying parents about fraud. And this is a big one, because misrepresenting a relationship to an individual so that such individual may gain access to the U.S. Refugee Admissions Program could make the qualifying parent inadmissible to the U.S., which means they could be deported. Also ineligible for certain immigration benefits, such as citizenship, and or render him or her subject to removal. That's the same as deportation. So if you need to counsel them that they must be completely truthful in this application, because any fraud that is discovered later could be cause for them to be removed from the country. A copy of all of the AORs that are filed in this program, the DNA results, the findings from the RAVU interview, which is the Refugee Access Verification Unit, the security screening. All of those documents become a part of the permanent file, the permanent immigration file for that qualifying parent. So all of that may be reviewed when the qualifying parent applies for additional immigration benefits. Excuse me. So let's go over the eligibility, starting with the anchor or qualifying parent. So those of you who are familiar with the P3 program, we usually call these people the anchors. In this program, they tend to be called the qualifying parent. In this presentation, I'll refer to them as both the anchor / qualifying parent. So this is the person who's in the U.S. that comes to you for help. They must be at least 18 years old. They must be lawfully present in the U.S. under one of these 7 statuses, okay? Only these 7 statuses. They can be lawful permanent resident. They can have temporary protected status. They can have parole as long as it's been granted for at least 1 year. They can be a recipient of DACA as long as it's at least for 1 year. They can be a recipient of other deferred action, non-DACA deferred action, as long as it's for at least 1 year. They can be the recipient of a deferred enforced departure, which is mostly Liberians right now, or they have been granted withholding of removal. So only those 7 legal statuses qualify. Now, on the instructions for the AOR, which those of you who are familiar with the current AOR, the first several pages are instructions. On there is listed the exact documentation that proves each of these statuses. So I'm not going to go through it right now. It's very cumbersome, but you need to refer to the instructions. So if you have someone come in that, say, is a DACA recipient, look up on the instructions, okay, what are the documents that prove that someone is a DACA recipient? Read that, and that's what they need to provide to you. And that's what you have to provide when you submit the AOR. An important point is, although the children have to be a national of one of the three countries, El Salvador, Guatemala, and Honduras, the anchor, the qualifying parent, does not. In most cases, they will be, but technically they do not. Now, it's important to note that U.S. citizens and refugees or asylees are not eligible to be anchors under this program. It's because U.S. citizens have, the visa application process to bring over family members, and refugees and asylees have the P3 program or the I-730. So there are other avenues available to people that are citizens or refugees or asylees. So they cannot file the CAM AOR. Now let's go into the eligibility requirements for the qualifying child. Now, those of you who are familiar with the P3 program, this is what we were calling the qualifying family member, the QFM. Now they're called the qualifying child. So it's the type A relative, and they're called qualifying child in this program. So they must be a national of El Salvador, Guatemala, or Honduras. They must be also currently residing in their country of nationality. They must be under 21 years of age, although there is no minimum age. They can be a week old, technically. I'll get into a little bit more about that in a second. They must be unmarried, both at the time of filing of the AOR and at the time of entry. With the 21 years of age thing, they have to be under 21 at the time of filing. If they turn 21 after that, it's still okay. They must be the biological, legally adopted, or stepchild of the anchor, qualifying parent. Now, that relationship must have existed at the time that the anchor received their legal status in the U.S. and at the time of filing. So what does that mean? Okay, so for example, for stepchildren, the marriage that created the stepchild-step-parent relationship, number one, it must have occurred before the child's 18th birthday, but it also must have occurred before the anchor, the qualifying parent, came to the U.S. and got their legal status, whether it be temporary protected status, DACA, whatever, okay? And that relationship, that marriage, must continue at the time that the AOR is filed, okay? So if there's a divorce, there's no longer a stepchild-step-parent relationship. For a child who was adopted, the adoption must have occurred before the child's 16th birthday, and the qualifying parent and the child must have resided together for 2 years at some point. So not necessarily the last 2 years chronologically, but at some point for 2 years after the adoption occurred, they must have resided together. And you also must provide the legal documents showing that there was a legal adoption in whatever country it occurred in. That has to be provided at the time of filing. And so finally, the qualifying child must qualify as a refugee or have a persecution claim, as I talked about initially. Now, I mentioned that a child could be a week old technically, so you're probably wondering, how does a baby articulate a refugee claim? Well, PRM has said that a guardian or an adult can come with a young child to articulate the claim for them if they are too young to articulate their own claim. I just got a question that says, does a divorced qualifying child with or without children qualify? Does a divorced qualifying child? Okay, so if the qualifying child was married but is divorced and therefore single at the time that the AOR is filed, then that's fine. They are eligible. They just must be unmarried at the time. So it doesn't matter if they were married previously. And they can have children. I will get to that part in a minute. So this is what I was just saying, that an accompanying adult can articulate the refugee claim for young children. But basically a child, and PRM hasn't given us very specific guidance on this yet, but a child who's old enough to be coherent is going to be expected to be able to articulate their own claim. So that's going to be difficult. So you need to be aware of that and counsel the anchors of that. So there's another type of relative. You may be familiar with the term derivatives from the P3 program, also called type B relatives. So in this program, there's also derivatives. And these are children of the qualifying child. Okay, so this gets to the question we just had. So as long as the child of the qualifying child is under 21 and unmarried, they can derive their status from the qualifying child, from their parents. They do not have to establish their independent persecution claim. Okay, so this is the only type of person that can get derivative status. And the child must also be otherwise admissible to the United States, must still pass the same medical screening, security screening, and whatnot. So this is the only type of type B relative in this program. There's also a type called an add-on parent or type C relative in this program. So what this is, the add-on parent is the other legal parent of the qualifying child. So you'll recall that the anchor, or the anchor/qualifying parent in the U.S. is one parent. Obviously, the child has another parent somewhere. So the other legal parent of that qualifying child may be eligible as an add-on parent. This person, excuse me, I'm having dry mouth. This person must establish their own separate persecution claim apart from the qualifying child. This person does not have to be a national of El Salvador, Guatemala, or Honduras. As long as the qualifying child is, the add-on parent does not have to be. And most importantly, the add-on parent must meet these three requirements. Whoops, okay, those went out of order, sorry. So number one, he or she must be part of the same household and economic unit as the qualifying child, and he or she is legally married to the qualifying parent at the time that the qualifying parent files the AOR, and he or she continues to be legally married to the qualifying parent. So I have a note on here that the current AOR form that we're going to be going over at the end of this webinar, it says in there a little bit different language for this requirement. But PRM changed it after the AOR was made. So when the AOR is updated in 6 months, this is what it will say. So these three requirements are the actual requirements, not what is stated in the instruction form on the AOR. So please make note of that. What the AOR form instructions say is that the marriage had to take place prior to the qualifying parent gaining legal status in the U.S. That's what they changed. So as long as they remain legally married, the add-on parent qualifies. So the marriage can technically have taken place after the qualifying parent came to the U.S. and got their legal status. But the main part of this is that this other parent has to be basically living and raising this child, living with and raising this child. They have to be part of the same household and economic unit. So an absent parent, obviously, is not going to qualify. An interesting part of this is that if this parent, this other legal parent, has unmarried children under 21 who are not also the children of the qualifying parent, okay, so they have a different, someone else is the mother or father, but they are living with this add-on parent, they can also be included as type C relatives. Okay, so the type C relatives can be the add-on parent plus any unmarried children under 21 of that add-on parent that is not also the child of the qualifying parent. Because if a child is the biological, adoptive, or stepchild of the qualifying parent, they're listed as a type A. Okay, they wouldn't be a type C, they would be a type A. That's why it's important to note here that this is for children who have the add-on parent as a parent but not the qualifying parent. I know this gets confusing. Please ask me questions if it's not clear. Let's talk about the parole option, which is unique to this program. So parole is a mechanism to allow someone who is otherwise inadmissible to come to the U.S. for urgent humanitarian reasons. So if someone who is ineligible for refugee status, and so by this I mean either the type A, type B, or type C, if any of them are ineligible for refugee status, they can be considered on a case-by-case basis to still be allowed to come to the U.S. on parole. However, people who come to the U.S. on parole, called parolees, do not receive the IOM travel loan, so they have to pay for their own way to the United States. They must also pay for their own medical clearance overseas in their country of origin. And when they get here, they will not be eligible for R&P benefits. So what's still a little bit unclear and that PRM is still working on coming up with more clear guidance on is that if a beneficiary is denied refugee status but then offered parole status, technically your role as the affiliate ends at that point, because then it becomes an immigration matter. Because then parole is handled not by the State Department, but by Department of Homeland Security, USCIS. That's an immigration matter. And unless you are BIA accredited, you won't be handling that aspect of it. But there may be situations where one or more of the beneficiaries listed on the AOR may get refugee status, but then the others don't, and maybe they're offered parole status. Let's say, for example, a qualifying child gets refugee status, but an add-on parent does not. So in that case, it's a mixed situation, and you'll still be responsible for the person that gets the refugee status, and they'll come to your agency when they get resettled and get the benefits through your agency and all of that, but you won't be involved with the person who gets parole status. Like I said, hopefully we'll be getting more specific guidance about this in the future. I don't know why sometimes my bullet points come up uneven. I'm sorry about that. I mean, in the wrong order. So someone for parole, they're eligible if they're at risk of harm, if they clear all the background and security checks, and if someone in the U.S. commits to financially support him or her. So what that means is the person in the U.S., most likely the anchor or the qualifying parent, has to file an affidavit of support. It's called a Form I-134. And like I said, that's an immigration form. That is not something that you as an affiliate, like I said, unless you're BIA accredited, can help with. So you're not required to assist with this. And in fact, if you do assist with this and you're not BIA accredited, you could be charged with unauthorized practice of law. So you really want to stay away from this. If someone comes to you and says, "Oh, my child, my whatever has been granted parole status. I need your help. Can you help me fill out this affidavit?" You have to refer them to a legal services provider. Now, the benefits of parole. The status is temporary, and there's been no guidance on exactly how long this status is going to be, and it does not confer any permanent legal immigration status or a path to permanent legal immigration status. So they also need to be aware of what parole means, that it's really not a path to citizenship at all, and it's only temporary. So generally, parole is granted for 2 years, and you can ask to renew. But as I said, in this particular program, they haven't specified how these particular parolees, how long they're going to be granted. But we're assuming 2 years until we're told otherwise. And like I mentioned earlier, they will not be eligible for benefits once they come here, specifically Medicaid, other benefits, state benefits. I would guess that it would vary by state, but my understanding is this class of legal status is not qualified for many benefits. They can attend public school, though. They are eligible to attend school with their children, obviously, and they can get an employment authorization document. So let's talk about the requirements that you have to provide to apply for this. So the documentation that you as the affiliate will need to submit to to ECDC with the AOR. Number one is the anchor/qualifying parent's proof of legal status. As I mentioned, look on the instructions of the AOR. Also in the guide that I sent out to all of you, I wrote a guide for this new program. They're all listed in there as well. So either look on the guide or the instructions for the list of what the documents are that prove the legal status. If the child's adopted, you must provide copies of the legal adoption papers. As with the P3 program, you must provide photos for each beneficiary. They must be passport-style photos with a clear, full frontal face view of each person for whom the anchor is applying. They must have been taken within the last 6 months, so they must be recent. And you should attach them to the AOR in only the .bmp or .tif format. Please take note of that because other formats will not be accepted. And something that I'm not sure if everyone knows, but these don't have to be, traditional passport photographs that are taken at a special place. They can just be snapped by a cell phone. That's fine as long as they meet all of these other requirements that I just went through. DNA testing is required for all of the qualifying children. This will happen after a pre-screening interview in the country of nationality. The anchor here in the U.S. will be notified to start the DNA testing. So the anchor tests first. They go to the lab. They pay for all the kits, so for themselves and however many children that they're testing for. Only AABB accredited facilities are accepted. There's a website that lists it. It'll all be contained, all the information will be contained in the letter that the anchor gets as well. Now, if the DNA confirms the claimed relationships, IOM will schedule a refugee interview with DHS. And even keep in mind that a positive DNA test does not necessarily mean that the applicants are approved for resettlement. It means that it's a positive DNA test and they continue on the process, but they still have to have security and the medical clearance. So a reimbursement check will be issued by IOM after the DNA confirms the relationships, but only if all of the relationships are confirmed. So if one comes back that, oh, that's not your kid, the rest of them are, sorry, no reimbursement at all. So that's another thing you need to make sure the anchors are aware of. So let's go through how this new CAM AOR is different than the AOR that you're all used to from the P3 program. As I mentioned, instead of a qualifying family member, the main person, the main beneficiary is called a qualifying child. Each qualifying child must be listed on a separate page in Section 2A. So if the anchor has 3 eligible children, there should be 3 Section 2s filled out. There's Section 2A, next page, Section 2B, next page, Section 2C. Each qualifying child has to have their own page. And then if there's an add-on parent, just go ahead and put them under, if there's an add-on parent that's also the parent of all 3 children, just put them under the first child. If you have specific questions that get into really detailed things like that, please just ask me when the situation arises. Now, when we go through the form, you'll see this. There's a space where you have to include the information about the child's other parent and the child's current guardian, if they're different. If it's the same, you'll put the same information, or you'll put, you'll just put the same information for the parent and for the guardian. If it's different, you have to put both. So the anchor can't say, well, I don't know who the father is, for example. That information must be filled out, at least a name. When I asked about this at the training, PRM was saying, they really need to put as much information as possible. They're not going to accept, it's saying unknown, unless there's extenuating circumstances, perhaps a rape or something like that. Then you could explain in the comment section in detail why that information is unknown. But generally, you need to push to get as much information as possible. A question just came up, guardians don't have to DNA test, do they? Well, I guess I don't understand this question because guardians don't qualify for this program, okay? If you mean the other legal parent, No, the other legal parent obviously does not have to do a DNA. Well, I shouldn't say obviously. The other legal parent does not have to do a DNA test. From what we've been told, it's only between the anchor and the qualifying child. So that's the relationship that must be tested. Perhaps more specific guidance will come out on that later, maybe to prove that an add-on parent really is the parent of the qualifying child. I'm not sure, but as of now, we're being told the DNA testing will be between the qualifying child and the anchor. But the question about guardians are not going to be eligible to come to the U.S. through this program. Okay. Let's see. The final thing is that I think you'll all be happy to hear this. I know one of the pains of the P3 program is having to list all of the brothers and sisters and all of that, the parents, all of the detailed information about them. You do not have to list that on this form. So you do not have to go into all that information about the parents and siblings of the anchor. So in terms of submitting the CAM-AOR, you'll need to download Serenade. You all should already have Serenade because you should all be submitting AORs to me already for the P3 program. But just in case you haven't done that yet, download Serenade from this website here. Then you'll fill out the form on Serenade, and you'll then convert it into a PDF. Oh, by the way, I'll email you the actual CAM-AOR form when I'll send out after this presentation the copy of the PowerPoint and the form. Also, I'll send out the guide again that I drafted and the processing diagram. So anyway, you convert the CAM-AOR into a PDF. Now, the way you do this is you choose Print, and then when you choose, you have to drop down, do the drop-down menu and choose PDF Creator as your printer under the Print option. If you don't already have PDF Creator on your computer, you can download it off the web very easily. There's lots of free sites that have PDF Creator. So it's not through Save As, which confuses people. You have to do it through Print. Then you email it to me at that address, along with the PDF of the proof of immigration status of the anchor, as well as if it's an adopted child, also the adoption papers. But generally, you're going to just be sending me the PDF of the proof of immigration status. So I'll then review the AOR, and I'll let you know if any changes need to be made. And if they do need to be made, it's really important that you make the changes and resend as soon as possible. Sometimes we get AORs back months later. And number one, it's hard for me to remember, and I have to search through and try to remember what I even told you when you submitted it before. But also, there's also some detrimental, consequences that could happen because the AOR is not technically filed until I submit it to RPC. So unless I have told you that the AOR has been submitted, do not assume it's been submitted. Okay? You must get a confirmation email from me saying I submitted it today. And so this is important because if the child's close to turning 21, and I got back to you and said there's some changes that need to be fixed, and you don't get it back to me and the child turns 21, then they lose their eligibility. So it's important to try to stay on top of that. Okay, so that's all the PowerPoint. So now we're going to review the actual form. Okay. So here is the new DS7699, the Affidavit of Relationship for Minors who are nationals of El Salvador, Guatemala, and Honduras. So this first page is a lot of instructions. This should look familiar to all of you. Right here under the Type C, this is the part where I told you this is not the correct eligibility information. Because let's see, they changed the way this is worded. So the correct way is what was in the PowerPoint. On the second page here, acceptable proof of eligibility. This is where the documents are listed for all of those different types of legal status. So this or in the guide is where you would look up what type of documentation you have to submit. So the rest of this is just general stuff that we've already gone over, but it's helpful to have it here. Again, the penalties for committing fraud, that's important that you go over with them, with the anchor. So and you're all familiar with this page that has the different types of relationship codes. All right, so getting to the actual form. Again, should look very familiar to those of you who are already doing the P3. The case file ID is the alien number of the anchor, just like in the P3 program. You select ECDC as your agency from the drop-down menu here, and then you put in your affiliate ID number, whatever it may be that ECDC, that PRM has assigned. For example, in Phoenix, AZ ECDC 01. So you should know what your code is for your agency. So you fill in the information about the qualifying parent, okay, the anchor, the qualifying parent. This is all standard. It should look familiar to you. You do have to list their current spouse, city, and country of birth. Then there's a drop-down menu for selecting the current immigration status, because as I said, only these certain ones are, these 7 statuses are accepted. And the date that the status was granted and the date of arrival in the U.S., these may be different, these may be the same, and the anchor's nationality. So Section 2A, so this is where we're going to put the first qualifying child. Qualifying child, see? So you've got to put their name, their sex, their date of birth. If it's estimated, check the box. City and country of birth, as well as their nationality. And then you select the relationship to the qualifying parent. This is the same drop-down menu as in the P3 program. Obviously, not all of these are applicable. They can't be the fiance of the qualifying parent. It has to be either adopted daughter or son. Foster does not count, so fosters are not eligible, so that wouldn't be it. Son or daughter, or stepson or stepdaughter. Those are the only options that you're going to be able to choose. And then, of course, this is where you upload the photo. So same information, the street address for the qualifying child. Now here's where I was talking about you have to put the contact information for the child's guardian. So their name and their relationship to the child could be friend, could be aunt, could be grandparent, whatever it may be. Put in as much complete information as you can here, because this is going to be important for contacting to schedule interviews and whatnot. And then also the parent of the child, if not listed above. Okay? So if the guardian is not the parent, not the other parent, you put their information here. The relationship is going to be either mother or father, obviously. If it is the same as above, you can just put same as above. Now, down here is where you put either the type B, derivative, children of the qualifying child, or the type C, add-on parent, the parent of the qualifying child, or his or her unmarried children under 21. Obviously, you can't list a parent's unmarried children unless you also list the parent. So you can only list this type of type C if you also have this type of type C. So they go together. But it may be that you don't have anyone in this section. This can be blank, and that's fine. I don't know why this keeps doing that. Okay, so you have to make sure you pick either that they're type B or type C from the drop-down menu. All the requested information here. The relationship, again, there's lots more options than what are actually eligible, so make sure you only pick an eligible relationship. And the relationship to the qualifying child. So you have to both state the relationship to the qualifying parent and to the qualifying child, and then upload their photo. So if there's another child, you list them on the next page, Section 2B, under A. And if there's a third child, it'll be Section 2C, etc. So each qualifying child gets their own page. And then moving forward, you do have to list the current and former spouses of the anchor or the qualifying parent, like you do in the current AOR, all the same sort of information there. And you do have to list any other children. So this is only for children that are not listed elsewhere in the AOR, okay? So maybe they have children living with them in the United States already. That's where you would list deceased children, those children. And then Section 4, again, this is just a place to add additional information if you need to explain something. Oh, I do want to point out for the Type C relatives, they did make sure, they told us that you have to explain in the comments section on the page where that relative is listed. So, you know, we're listing John Doe here, etc. We have to list here those 1, 2, and 3 that they meet those 3 requirements: the sharing the same economic unit and household, the marriage to the other parent, and that the marriage still exists. So in some way, you have to address those 3 eligibility requirements in the comment section on the page where that Type C add-on parent is listed. Also, if you have any other Type C relatives, the unmarried children of the add-on parent, just describe that further here. I would say something like John Doe also has other children that are not the children of the qualifying parent. These children live with him. He is financially responsible for them, something of that sort. Describe the relationship in the situation and why they should be included as add-ons. Again, as a reminder, only the last name should be in all caps. Please do not do the entire AOR in all caps. Only the last name in all caps. The rest should be regular capitalization. And then as we get to the signatures, electronic signatures are accepted. So you're submitting this to me electronically. So obviously the anchor is not going to be able to actually sign this. So just go ahead and type in their name on the signature line, and then again type it in again on the print name line and the date. You're going to put your name there and there, and your affiliate's name and address here and phone number. So, but when you print, you also need to print this out. And in that case, what I would do it this way: print it out without putting in the person's name in the signature box, so that the anchor can actually sign the hard copy, because you are required to keep a hard copy of this with the anchor signature in your case file. So print it out, have them sign it, then you can come back and add in their name again, save it as a PDF at that point, whatever, and then you send it to me. But please keep a copy of all of the accompanying documents as well as a hard copy of the AOR signed by the anchor in your case file. Okay, that is the end of my presentation, and wow, look at that, it's only 2:53. I'm 7 minutes shy of an hour. So does anyone have any questions at this point? I know this is a bit complicated, so may take you a little while to go through the guide, work through it a little bit, and then you'll find that you may have some questions that come up. Feel free to contact me, of course, with any questions that may come up or something that's not clear. So I got a question: are you sending out this information to us? So what I'm sending to you, you should have already received the guide that I wrote, the CAM AOR guide, but I'll send that out again. I'll send out to all the people on this webinar right now, all the people who registered. I'll send you a copy of the PowerPoint, a copy of the guide, a copy of the processing diagram, the flow of how the process goes, and and the actual AOR form. So yes, I will send that all out to you. While I'm waiting to see if there's any other questions, I may just pull up the processing diagram really quick to go through with you, just to show you how this works. So this is the processing flow. It's very similar to the current P3 program. So first, you guys fill this out using Serenade. You submit it to me at headquarters. I review it and do quality control. Once it is in a good form, I'll submit it to the RPC. The RPC then vets it, makes sure that they don't see any problems, and they'll also do a paper review of the legal status, the proof of legal status that was provided. They will then enter the information into RAPS and submit to the RSC. The RSC is in Quito, Ecuador, by the way. At that point, the case is pre-qualified. The RSC creates the case, schedules the pre-screening interview. They conduct a pre-screening interview and the DNA counseling. I mean, I'm not going to go through this whole thing. You guys can read this, but it's as you can see, it's a very lengthy process. This is an interesting point as well, in this one too, where access is granted. So this is the point where they actually have been granted access to the U.S. RAP, not meaning that they've been granted refugee status, but where they've been granted access to the program. That's when they start security clearances. That's when they do the interview with USCIS. That interview is what will determine whether they get refugee status, and they'll continue through the RAPS processing, or whether they're denied completely and the case is closed, or whether they're considered for parole. If they're considered for parole, that information is entered into RAPS, but the case is technically closed as far as the State Department is concerned. And then I'll let you read through the rest of this. So let's see. I have a couple more questions. How the kids have persecution examples. Okay, so how can a kid have persecution? Well, I don't have very many examples, unfortunately, because not many have been provided to us. But there may be a situation where a child, say, belongs to a certain church, or a youth group, or something like that. So that's a religious-based organization, and that particular group, that particular youth group or church, is being targeted by a gang for recruitment purposes or extortion. But actually not just extortion, because there has to be some violence, threat of physical harm as well. It can't just be financial harm. So unfortunately, like I said, this is going to be hard to prove that these kids actually qualify for refugee status. But when I brought this up at the training, I was told that it is not our job to teach the anchors what will or will not qualify for refugee status. In fact, we are prohibited from doing that, okay? So I don't want you guys to get caught up on, well, what exactly does that mean, and how can a child qualify for refugee status? That is not our role. Our role is to assess whether they're eligible under those eligibility requirements that I mentioned to you, and to file the form for them. It's then up to USCIS to determine whether or not the child qualifies for refugee status. So I hate to say it that way, but really we are not supposed to be making any kind of determination of that, or even suggesting to the anchor whether or not a child would qualify. Okay. Let's see. In the event that the qualifying child is unmarried with children, if he or she has a domestic partner that is the parent of the children, the partner will be an add-on. No, that is not. There is no place for the other parent of a qualifying child's child. I think that's what that question is getting to. So if a qualifying child is unmarried and they have a child, that child's other parent is not able to be added onto this AOR. They do not come under any of the categories that I went over. So no, that other parent of the child's child cannot be added on. Question: if the child will be killed because of his father threat. Abdul, your question got cut off. I didn't get all of it. Again, I hate to get into specific questions about what constitutes refugee status or not, because that, like I said, that's not up to you guys to try to determine or try to counsel the anchor on. That's up to the asylum officers that are going to be conducting the refugee status determination. Okay, so don't get too hung up on that. And also, if they don't qualify for refugee status, but let's say they're being threatened, you know, because of a certain, because maybe who someone's father is. They're being threatened because their father, whatever, you know, but it's only the family relationship is the only reason they're being threatened. That doesn't qualify you for refugee status, but it may qualify them for parole status. So even if they do not qualify for refugee status, they may still qualify for the parole status, and so in that case, it's still worth it for the anchor to file. So don't get too hung up on that, guys. Any other questions? Is there anything I didn't answer? Everything clear? This webinar will be put on the ECDC YouTube page. If you're not already familiar with that, please go to YouTube and Google Ethiopian Community Development Council, and you'll see that all of our webinars are there. So if you need a refresher on, you know, how to handle minor cases, or a refresher on the P3 program, or any of the other great webinars that we've done recently, like Katie did one on the strengths of Congolese refugees that was really great, go to the YouTube page and you can watch those anytime. And so if you have a coworker perhaps that couldn't be on this webinar today and they really need to learn about this program, they can watch it on the YouTube channel. They don't get to ask questions like you guys do, but at least they can watch it. So with that, it is now 3 o'clock, and I see no more questions, so I'm going to end the webinar at this time. Thank you all so much for your attention. I appreciate it, and I'll look forward to hearing from you soon, either submitting these CAM AORs to me or asking me questions. Thanks a lot. Bye, everybody.